This is the people of the state of New York against Donald J. Trump. Indictment 71543 of 23. Appearances. By the people first, please.
For the people, ADA's Joshua Steinglass, Christopher Conroy, Susan Hoffinger, Matthew Colangelo, Becky Mangold, and Kathy Ellis.
Good morning.
Good morning. Emil Bove for Donald Trump, who is seated to my left. And I am joined with Todd Blanche, Susan Nichels, and Kendra Wharton.
Good morning, everyone. Before we put the witness on the stand, there is one issue that I did want to clarify, and I'm addressing this to Mr. Trump. It came to my attention that there may be a misunderstanding regarding the order restricting extrajudicial statements and how it impacts upon Mr. Trump's right to testify at trial. I think it's important that I clear up any misunderstanding that might exist. I want to stress, Mr. Trump, that you have an absolute right to testify at trial, if that is what you decide to do after consultation with your attorneys. That is a constitutional right that cannot be denied or abrogated in any way. It is a fundamental right that cannot be infringed upon. Just as you have the absolute right not to testify, if that is what you decide to do after consultation with your lawyer. The order is restricting extrajudicial statements. That does not prevent you from testifying in any way. It does not prohibit you from taking the stand, and it does not limit or minimize what you can say from the witness stand. In fact, as the name of the order indicates, it only applies to extrajudicial statements, that is, statements that are made outside of court. It does not apply to statements made from the witness stand. Please let your attorneys know if you have any lingering doubts or questions that need to be clarified, and I will try to answer them for you. Anything else?
Your Honor, not with respect to this witness, but I do believe that we will have some evidentiary objections to what we believe will be the next witness, which we can handle now or after this witness, whichever.
Why don't you start?
Sure. So we understand that the next witness is a summary witness and intends to get in a number of exhibits that we have, business records, foundational objections to for all of them. But then we have other objections for 3 of them, Your Honor. So the first one, I can start with the business records exemption. So we understand that the proffered evidence include 2 truths, alleged truths by President Trump, a handful of tweets by President Trump, and a tweet by the Washington Post, and then a news article by the Washington Post. We believe there are hearsay problems with each of these exhibits without the proper business record foundation being laid. So with respect to the truths, it may be that by a preponderance of the evidence, the statement, that the truth itself could be allowed into evidence without a statement of the defendant. But there is a lot of information on every tweet, for example, the name at real Donald Trump, the time it was sent, and other information. That's hearsay. And that hearsay we don't believe is admissible through just a summary witness who doesn't have any foundational expertise to talk about the basis for how the date is put on the tweet, how, the typical things that you would expect for any type of business records. The same thing with the truths, Your Honor, the same exact problem. There is content within the truth that purportedly they will argue are President Trump's statements, but there is a lot of stuff in that exhibit that is, 1, pure hearsay, and it is an out-of-court statement that be offered for the truth of the matter asserted, the date, the time, the handle. And without a proper foundation, we object to that coming in. The straight and the same is true of the Washington Post tweet for the same reasons. And the same is true of the Washington Post article for the same reasons. Separately, for 3 of the exhibits, putting aside the hearsay objection, we don't believe they should come into evidence. Turning first to 405A and B, 405A is the Washington Post article dated October 7, 2016, laying out the purported Access Hollywood tape. Your Honor's ruling a couple of different times, including from the motions in Lemeen, about what would be and what would not be allowed in with respect to the Access Hollywood tape. The original ruling said no tape, but witnesses could testify about it at the beginning of the trial. There is now going to be an email introduced that has a transcript of a portion of that Access Hollywood tape. What the people want to introduce now under 405A is the full, what amounts to a full transcript from the Washington Post article. And sure, there can be an instruction that says it's not offered for the truth, but there are quotation marks around the entire article, and so the danger of unfair prejudice is extreme in this situation. Remember, the only reason why the access tape, Hollywood access tape, is coming in at all in this trial, under the court's ruling, is to show intent and motive, and to show how the campaign responded, and why they responded the way it did. There is already a ton of evidence about the Access Hollywood tape from Mr. Pecker, from Mr. Davidson. I expect there will be a witness today that will testify extensively about the reasons why the Access Hollywood tape, even on the fringes, are allowed.
What are you asking me to do?
To exclude 405, and to exclude 405B, which is a tweet that went on at the same time, on October 7th, 2016, at 4:05 p.m., that has a photograph of President Trump and Billy Bush and one of the women that was part of the interview, and it says, "Breaking. Trump recorded having extremely lewd conversation about women in 2005. And then it says, Trump recorded having extremely lewd conversations about women in 2005 inches, actually in the photograph as well. I mean, at this point, and we are happy to address the Weinstein decision. The Weinstein decision, as it pertains to this, but what the court has already done, and what the court should do, in light of the Weinstein decision, is be very careful about the letting in this kind of evidence.
When you say the Weinstein decision, are you referring to the Court of Appeals reversal?
That just came down, Your Honor.
That's a decision that deals with Sandoval and Molyneux. I don't see it having any impact on my ruling.
Well, Your Honor is letting this in on, at least in part, on a Molyneux.
The Court of Appeals didn't lay out any new law, they simply ruled on the facts of that case. But the Molyneux ruling, the law that applies to Molyneux, the law that applies to Sandoval, it remains the same. And that's the same standard that I applied when I made my decisions.
Judge, agreed. Even under that application that you applied, it would be extremely unfair and extremely prejudicial, given the court's ruling already, to now extend it more to say that there is only going to be testimony, there is only going to be multiple witnesses.
I don't necessarily disagree with you. I'm just saying that the Weinstein decision doesn't necessarily factor into this.
Well, do you want me to do? Do you want me to do the final exhibit or wait until later?
No, go ahead.
The final exhibit is 408B. It's an alleged truth that is dated August 4th of last year at 4:16 p.m. It says, "If you go after me, I'm coming after you." This truth has been extensively discussed and briefed in the D.C. case, and the absolute reality is, and there are news articles that I'm happy to pass up to the court that make this plain this
Thank you.
This truth had nothing to do with witnesses, had nothing to do with the case. It had to do with what had been going on for a month in July and leading up to the beginning of August within the Republican Party. There was a massive movement by certain PACs and certain individuals to vocally tell everybody within the party, we're going to spend a lot of money to make sure that President Trump doesn't get reelected. And the campaign, not surprisingly, reacted forcefully in articles, in statements, and then ultimately with this truth. It had nothing to do with witnesses. And by the way, there has been oral argument in D.C. There were briefings where the prosecutors in D.C. suggested that this is one of the reasons why protective orders should be put in place, and then later a gag order. But when pressed, there has been no proof to disprove that. So when the context of it comes into evidence here, there is no basis for it. They may be able to prove up the theory they have about some of President Trump's truths and tweets, and how it may or may not affect witnesses, but not this one. This one has nothing to do with witnesses.
So I appreciate that you have given me a sense of what it is that we are looking at. I think we are going to have to devote a little bit of time for this, and we have the jurors waiting, so we will take it up later. There is just one of the issues that you raised that I would like to hear from the people on, and that is the photograph of Mr. Trump.
Sure.
People, I would like to hear from you as to why you feel that you need that.
Yes, Your Honor. With respect to 405B, I will just say that as Your Honor noted during the April 15th offer of proof, that's transcript page 34 through 35, Your Honor's ruling was that we could not play the Access Hollywood tape itself, not that other references to the tape can't be brought in. And Your Honor ruled that a full transcript of the tape was, in fact, admissible under appropriate circumstances. This would just be a screenshot of the publication of the underlying article via Twitter. Secondly, Your Honor, in any event, we are not introducing this exhibit or 405A for their truth, but merely for the date and time at which the article was published. If the defense is going to stipulate to the date and time, we will withdraw these.
I agree with everything that you said as far as my rulings, and you can introduce a transcript. I don't have a problem with that. I don't see the need for this. This goes to the reason why I kept the tape out in the first place. I don't want those words to be associated with Mr. Trump's face or his voice. It's just very powerful evidence. It's damning evidence. And I don't think it's necessary. You are going to get to read the transcript. You are going to introduce testimony about it. This is not necessary.
Your Honor, would you be amenable to us introducing it if we block out the picture and just introduce the date and time that the article is published?
And what is the purpose?
Just to establish the original date and time that the Access Hollywood tape story was published.
Mr. Blanche rises.
1 second, Mr. Blanche. Is there no other way to establish the date and time of this tape?
The other way would be through Exhibit 405.
Your Honor.
Which is what? I don't know it offhand.
Which is, this is the original version of the article, which was published or retrieved from a website called The Wayback Machine, which finds previous versions of websites and shows the original date of publication.
All right. So the people do have a right to establish the date that it was printed. You may want to stipulate to that. I don't know if you want to stipulate to that, but if you don't, I do have to give them the opportunity to establish that.
May I propose something second, potentially? If they show the witness, just the witness, either the article or the tweet, and say, was the article published on this date, at this time? Does that refresh your recollection? We're not objecting. And the witness can say yes. I mean, that's all they're offering it for, apparently. Anyway, that's the way that you can get it in.
I will have it to the people, if that's satisfactory. They may want to have something more physical, something more persuasive than just the witness having their memory refreshed.
It's also in the email, Your Honor.
And more than just having their memory refreshed. You can sort it out. I think the people can establish and should establish the date of the tape, and they should be given the opportunity to do that. I don't want this picture to come in, okay?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Let's get the witness, please.
Judge, can we approach briefly on an issue related to the witness on the stand?
Sure.
At sidebar.
I just wanted to raise, so they handed us exhibits yesterday, including what they have marked as G1 and G2, which are internal emails from the district attorney's office that relate to Jeremy Rosenberg. They are basically HR emails about the issues surrounding Jeremy Rosenberg. This witness has never seen these documents. He would have no knowledge of them. You know, he may have met Jeremy Rosenberg at some point. He doesn't know Jeremy Rosenberg, so I just want to be very careful. I mean, my view is they shouldn't be in any way read into the record or anything. I guess if they wanted to show them to the witness and ask him if he has ever seen them, maybe they can do that.
So we seek to ask the witness the questions to impeach the chain of custody on the two devices that he has testified about. And so what I would like, and Mr. Rosenberg is the person who turned the phones over to HTAU for both phones. There was a delay in the period of time between when he picked the phones up and when he dropped them off. For one of the phones, it was about 4 days. For another one, it was overnight. That was part of the reason that Mr. Rosenberg is the...
I understand why you want to impeach him. I don't have a problem with you wanting to impeach Mr. Rosenberg, but I don't think that this is the right way to do it. You can ask the witness, who did you get the phone from? Who retrieved the phone? Who gave it to you? If you would like that on the record that it was Mr. Rosenberg, and you ask him specific questions about the timing of all that, but you can't show him HR documents.
I'm sorry, I didn't mean to cut you off.
It's all right.
I don't plan to show him the documents or to try and refresh him in any way. I would ask permission to put questions to him along the lines, are you aware that Mr. Rosenberg was disciplined on this basis?
I don't think that's appropriate.
If I could hand up.
Sure.
This is the Court of Appeals in People v. Baez, and I'm focused on the language of beginning with subsection 2 that talks about the defense's ability to impeach on the basis of the gaps, just like this. So just the fact that these things were violated, they violated the district attorney's office policy to such an extent that there was discipline on this basis.
But you can call the witness, can't you? You can call a witness if you want. You don't have to use someone who is a technical person to help you establish bias or prejudice or anything like that with this witness. You can ask him, where did you get it? Who gave it to you? How long did it take? All of that is relevant to his testimony, but I'm not going to allow it.
Just so I understand, then we will be permitted to call two different witnesses from the government to establish the facts that led to the gaps in the chain of custody? Because these things...
Is that what I just said?
Well, that's why I'm asking, Judge, because these things go to the reliability.
You can try to call any witness that you want, and we will have to decide if it's relevant, if there is a basis relevant to the case or not.
These things go to the reliability of the evidence.
Mr. Bove, I'm not going to allow it.
Yes, Judge.
Thank you.
Sidebar concluded.
Okay, let's get the witness, please.